for helping us to understand as we go through these proceedings. We ask that you also assist those who are part of these proceedings to help them with their thoughts as you guide us throughout today and forevermore. Amen.
Amen. Thank you very much. Any apologies for absence? No apologies? Anybody? No? Okay, thank you. So we have online Senator Cherie Golding Campbell, Senator Janice Allen, Senator Morris, Gabriela Morris is online now. Okay, so we have 3 persons online. And Colette Curlew from NCDA and Ms. Cunningham from the House of Parliament. She's online also? Yes. Okay, Ms. Cunningham from the Houses of Parliament. So.
And Chair, may I just say thank you. I know this is not your favorite way of managing your meetings. I do appreciate the accommodation.
Your sweet words of encouragement will get me all the time, Senator. You're welcome. All right. So it's just for me to welcome you. We're going to try and close the meeting at midday, and so we're going to go right into it without much comments. Just to say that a lot of work to be done, and we're going to try and see if we can use the next few meetings to complete this phase of the process. So we're going to move right into the minutes.
Chairman.
Yes.
I have not read the minutes. I was wondering if other members have. If not, we could defer to the next meeting, the reading of the minutes. Okay. But whilst you deliberate on that, Chairman, I just want to, unusual for this meeting, but in light of what has happened recently, to congratulate you on your ascendancy to the presidency of the Executive Committee of PAHO, and genuine congratulations. No. And just to wish you all the best as you deliberate with colleagues in the Americas and the Caribbean to do what is best for us in terms of health. I know you had a little side steer recently when you were chairing a particular committee of PAHO, but this is the big one, and congrats again on behalf of us, the members of the committee, and even my side.
Thank you very much, colleague. I really appreciate the encouraging words and the commendations, and thanks to my colleague and to those in the Americas for allowing me this opportunity. Proud moment, not just for me, but I think for our country, Jamaica. It shows that we can offer leadership at different levels, and I will accept and lead with humility, and I'll carry the Jamaican flag high. Thank you. All right. So you were suggesting that we forego the minutes. Chairman? Yes.
If I may, in the same vein as Member Guy, on behalf of the technical team in support of your efforts as Minister of Health and Wellness, we would also like to extend our own congratulations and continued support in your efforts at every level. Thank you.
Thank you very much. All right, so you were suggesting that we forego the minutes because you haven't had a chance to go through it?
That was just a selfish request. I don't know about the other members who have read, and if so, then certainly I would yield to the membership, but I have not had an opportunity to read.
So in the usual approach to sort of agreeing by consensus, we have other members, any objections to this?
No, sir, we're not objecting to this selfish request.
Okay, and I don't see anybody else suggesting otherwise, online or in the chamber. Okay, member, we will concede to your request and go through the minutes next time, both minutes at that time. All right, so we will therefore forego matters arising and confirmation and go to new business. So what I was hoping to do, colleagues, given that we have been at this for a while and the last time we got stuck on very important clauses of the bill, wanted us to focus on clause 8, 9, and 10, because I think they represent the substantial points of difference, if you will. And we do have a letter which I think should have been circulated to all, addressed to the Permanent Secretary from the Attorney General's chamber, looking at those particular areas and making fairly lengthy recommendations in terms of an approach. So I think that this may occupy our minds for a little bit, and I do believe if we can address this area, then the other areas would be relatively easy. So let's try and see if we can get through this. I appreciate from the Attorney General's chamber the thought that was put into this. Clearly, you have done some work, and we just want to express our appreciation to you for that. It may mean that you will have to take us through what is being suggested here for the benefit of the committee and allow the committee to ask any questions around it. So if we're agreed on that, members, that we could just move to those 3 items since they are the substantial items. I see no objection. Okay, so we'll do that.
Chairman, if I might,
Yes.
I think it is absolutely critical that the Attorney General's chambers take us through it, because I certainly haven't had a chance to go through it, to read it even from a cursory point of view.
Okay, so could we then just have them make a brief presentation / overview of this document? Is that acceptable?
Yes.
And then we can chime in after and tell us exactly what you're replacing with what, which the document captures. Yes, Senator.
Thank you, Chair. Good morning, everyone. Again, my apologies for having missed the last meeting. I reviewed it, and there were just 2 or 3 little things that I'd like to put my word in on.
You want to do it now, or you want to allow them to present?
I could wait. Well, I wouldn't want to retract. Some of them are relevant to other aspects, like the public spaces and the reflection that you had around minors. I would just make the suggestion that we probably say public spaces, the higher fines. You had indicated your suggestion that higher fines be applied. And there was a question as to, I think Senator Gale raised in home, etc. And what my thoughts were that perhaps we could limit it to say, or restrict it to say, public spaces that minors might be in.
Okay.
And also, I think that there is an application in terms of less than 18 years of old, less than 18 years of age. So if someone delivers it to a home, they're already breaching the age limitation.
Yeah. So why don't we have the presentation,
right?
And then you can
and then
revisit
after,
those
okay.
issues.
All right. Thank you.
All right. So who would lead the charge here now from the AG's
All right,
chamber?
that would be me, Chairman. That would be me.
Yes, of course. All right.
Good morning, Chair, colleagues. Sorry, members of the committee, colleagues. So a document was circulated to you this morning. We apologize for the late delivery of the opinion, but as you are aware, we also have other competing interests and other urgent matters that also delayed us. This is actually a compilation of views coming from the Legal Reform Department, represented by the Director of Legal Reform, Nadine Wilkins, from the Office of the Parliamentary Counsel, represented by Mrs. Petrona Seeley-Brown, who is a consultant drafter, Ms. Auld, and myself. So we met and we discussed the issues that arose from the Joint Select Committee meeting as it relates to clauses 8 and 9 and 10. We also looked at the proposed amendments that were circulated, the ones dated August 26. We also considered case law, which led us to a case considered by the Constitutional and Human Rights Division of Kenya, which reviewed their Tobacco Control Act and their tobacco control regulations. And arising out of all of that, we have a summary of recommendations. So if you want to go to the document, you could actually just look quickly at this page 2, the summary of recommendations. where we propose that we would replace clauses 8, 9, and 10 with provisions coming from the Kenyan regulations or aspects thereof, noting though that we wouldn't necessarily be taking them wholesale, one, to accommodate our own legislative framework in Jamaica, and two, to accommodate the policy emanating from the Ministry of Health and Wellness. So a little background, especially as it relates to Clause 8. Now, Clause 8, as you will recall, deals with, the marginal note says, limited interactions with the tobacco industry by a person who has responsibility for tobacco control. And you will recall further that there were some proposed amendments to Clause 8 on which the Attorney General's Chambers had submitted some concerns about. So a few issues that we had, which the Ministry of Health and Wellness did try to respond to, was the fact that it appeared to infringe a fundamental human right. And I would go further to say perhaps more than one, freedom of association being one of them, and perhaps also the equitable treatment by a public authority. Because what this is doing is saying that you're going to treat with the tobacco industry differently than you treat with industries that perhaps create the same or similar dangers. For instance, the industry that governs marijuana or the alcohol industry. And you're treating with the tobacco industry in a different way. The issue is whether this can be demonstrably justified in a free and democratic society, which is a test we have to say that whenever a fundamental right and freedom that is captured in Chapter 3 of the Constitution may be infringed, you can infringe if you pass this constitutional test. And there are a few things that the court considers when looking at the test. One, do you have a law that allows you to infringe a right? It has to be done by a law. Is that law carefully designed? How did you craft the law? Did you try to minimally impair the right as best as possible? So these are aspects of the test that we have to consider. Another part of the test that will arise thereafter is a balancing act. Because at the end of the day, you have to still look at the interest of the individual, the interest of society, and see which would outweigh the other. So I'll just jump right into Regulation 22 of the Kenyan regulations, which are 2014 regulations. So they are quoted in detail. Regulation 22 is on page 4. And from our perspective, noting the decision of the Constitutional Court in Kenya and considering the scheme of these regulations, it is our opinion that these regulations provide a more focused scheme to address limiting interactions with public authorities, public officers, and the tobacco industry. And it is more a carefully designed scheme that achieves the objectives of the Framework Convention, Article 5.3 of the WHO Framework Convention, and guidelines, which we also want to comply with. And it would, from our perspective, do a better job of meeting our constitutional test. So the first provision says any interactions between public authorities or public officers and the tobacco industry shall be limited to the extent strictly necessary for effective tobacco control and enforcement of relevant laws. As I go through, there are aspects of it that at some point, if you agree on the general policy or scheme, the drafters would then have to refine the language to ensure that it meets the policy of the Ministry of Health and Wellness and also conforms with the discussions that have already emanated from the members of this committee. So the second provision goes on to say a minimum of 2 public officers shall be present in any interactions with the tobacco industry. So what that does is it provides a framework where it won't be a he said, she said kind of situation if you have a meeting. You will always have, let's call it, another independent observer. Before commencing any interaction with the tobacco industry, the public officers are to state in writing that the interaction does not imply an endorsement of tobacco industry practices and that no relationship, collaboration, or partnership shall be construed whatsoever from the interaction. This is more out of an abundance of caution sort of provision to say that no matter what, nobody can infer anything from the interaction. You can't infer that there is an endorsement. You can't infer that there is some agreement emanating from that interaction. Strictly speaking, it may not really be necessary, but it is something that I think could be useful and can provide protection to the actual public authority or public officer. You'll note that, so in 22.1, it spoke of responsibilities on both the public authority and the public officer. But in 4, you will see now that it drills down to a responsibility on the public officer. And it says the public officer participating in any interaction with the tobacco industry shall prepare a formal record of the interaction and submit to the relevant public authorities. And this says including the Cabinet Secretary on request. Now, the framework in Kenya is slightly different than ours, and this is perhaps why they would have, you will see that the role of the Cabinet Secretary there is a little more prominent than how we would do it here. My suggestion would be that the record would be submitted. If we're going to use this provision, it would be submitted to that person's supervisor. It could be a director. It could even be the permanent secretary in the ministry. If the public authority is not the ministry itself, then it could be some very senior officer within that public authority, but not necessarily the cabinet secretary. 22.5 of the Kenyan regulations then goes on to say, interactions with the tobacco industry initiated by a public authority at the national, regional, county, district, urban authority, or local level shall take place in public venues determined by the public authority. And perhaps what I should have done was indicated, because I did not include that in the opinion, that interactions is actually defined in the regulations to mean meetings, correspondences, and other exchanges between public authorities and the tobacco industry or its affiliates that arise when public authorities meet in a common forum with the tobacco industry or its affiliates, whether directly or through third parties. So although you're supposed to be meeting in a common forum, 5 is going further to say the interaction should actually take place in a public venue. I do have a few concerns because I don't know, for instance, what would be considered a public venue. So for instance, you have a meeting in the conference room of the ministry. Is that a public venue? I'm not quite also sure if this is absolutely needed in light of the whole definition of an interaction. But again, it's something to be considered. 6, interactions with the tobacco industry shall not take place within offices or other facilities of the tobacco industry, except in the course of enforcing or ensuring compliance with the law. So for instance, I guess if you are doing an inspection, clearly it would fall outside the remit of this provision. A public authority or public officer shall not accept any offers of hospitality from the tobacco industry or its affiliates. And then the final provision of Regulation 22 says, a public authority shall not accept any direct or indirect funding from the tobacco industry or endorse projects which are funded directly or indirectly by the tobacco industry. So what you have here is a lot more detail than what we have in our Act. Admittedly, these are regulations, and you would expect to have this kind of detail in regulations. But just to explain, the Kenyan Act, the Tobacco Act itself is actually it's small. It does not contain the kind of details our Act contains. What they did was to put all their details in their regulations. So I don't think it would be out of place for us to put some of this kind of detail in our Act. Of course, it would be now left for discussion to determine what you think would be appropriate or not. You will finally notice that this is not subject to any criminal sanction. And this is a position that we endorse, and part of the reason is the scheme. So it goes on not just to limit interactions, but then it goes on to a more fulsome sort of disclosure scheme, which is something I know a member of this committee had raised, and is usually the scheme that we are more familiar with when we have legislation dealing with boards. You have a conflict of interest. What you're usually required to do is disclose and then take action thereafter. So I don't know if you want me to pause now before I continue, or should I?
It may be useful to avoid sort of missing some of the critical issues. You want to comment?
If I could.
All right, so I see Member Guy, yourself, Member Bolden Campbell, and then Member Gale. And Mr. Edwards, I'm going to ask you, you're going to be important to comment also, because I want to hear how you reconcile what you have versus what is being proposed. All right, you want to?
Thanks, Chair. SG, you, in your research, you went to the Kenyan High Court. Are there any other rulings that you have seen which may support this particular point? And I ask against the background of we have relied extensively and referenced extensively the Guyana legislation. Now, is it that Guyana's constitution does not have a Part 3 as ours does, which puts us in a peculiar position why you are suggesting that 8, 9, and 10 be deleted? Or has it not been challenged yet in the court? 2, can you explain for us in the committee who are not lawyers then why you are moving these recommendations from part of the statute to regulations, these arrangements to regulations, as opposed to being directly what we would want in 8, 9, and 10, because they would accomplish exactly what we would want there, with minor tweaking, of course. And yes, those are mine for now. Thank you.
Okay. Thank you, Member, through you, Chair. So actually, I was provided with case law from Mr. Edwards, who kindly provided me actually 5 cases. I have not seen any case law from Guyana, so I'm not able to say, I haven't seen anything from Guyana. Why I'm taken with the Kenyan approach is that their constitution is similar to ours. The test that they used in their constitutional court is very similar to the test we apply in our courts. And it's similar to the test coming from Canada, RV Oaks, which is a 1984 case. So it is very similar, and it is something that we apply here. So that's one of the reasons why we thought it would be appropriate to look at these Kenyan regulations. I'm not suggesting we move the provisions from the bill to regulations. What I'm suggesting that we put these provisions in the bill. And I was just trying to explain that normally, and in fact, the Kenyan approach was to keep them in regulations, but our approach has been to put a lot of meat in our bill. So I'm suggesting that all of this would go in the bill, not in regulations.
Can I, before I ask Senator Golden, Campbell, and Gale to come in, I think Mr. Edwards' comments on these changes, maybe germane, given that he has been driving the process from our standpoint, to see if we could. Are you reconciled in your mind, or what would be what are your initial comments on this, Mr. Edwards? Sorry, colleagues, I'm going to bring you in right after.
Chair and members and colleagues, first of all, I would like to express appreciation again to the Attorney General's Chambers, Legal Reform Office of the Parliamentary Council for the effort in putting together these thoughts and this perspective for our consideration. These proposals are not new to us, I would say, because as SG indicated, we have shared some material with the chambers, and the approach of Kenya is not something that we are unaware of. It is a little more detailed than we had originally proposed, but in terms of the principles underlying the approach of Kenya and the perspective in relation to balancing interest, the ministry does not have a difficulty. Our only concern would be and I think SG has indicated that some aspects may be, I don't want to say optional, but there's some aspects that are for consideration and may not be required in terms of some of the level of the detailed steps that persons go through as stated in the Kenyan regulations. But the broad principle in terms of seeking to manage the control of interaction and protecting the public official also, because some of these steps are potentially protective of the public officials and public authorities. So we are able to reconcile. And therefore, Chair, we see this in a sense as building on what is in the bill.
Before I ask my colleagues to come in, let me just kind of capture in my own mind what we're trying to achieve here, what's the injury that you're trying to correct. The issue is that in the current bill, these clauses kind of creates an all-encompassing extreme position around interaction with the tobacco industry, while the proposed alternative is attempting to be more specific, which I think explains the more details, which is why I don't necessarily agree with you that the details shouldn't be there, because what you're actually trying to do is to narrow the focus where you think the greatest potential for conflict could exist while preserving the rights of legitimate authorities, whether institutional or individual, from getting caught up into that kind of conflict. Am I kind of assessing it correctly?
That's exactly correct. And
okay.
Perhaps I should have, sometimes I'm not a big frills person, so I really should have explained that when we say delete and replace, it's not that what's there does not have the substance of the Kenyan regulations. It's just that it didn't have the kind of detail and it didn't have that narrow focus, which is something that we can use to be able to demonstrate the careful design of the law, the fact that we are not going to be impairing everybody's rights unnecessarily, and that you focus on the public official when you need to, you focus on the public authority when you need to.
Let me play devil's advocate again. Please indulge me a little bit. Suppose, I don't know if you know about campaign financing laws in the U.S., which requires limitations and caps on campaigns, but then you have these independent, quote-unquote, bodies popping up all over the place and essentially adding layers of funding to those causes and claiming independence while they're at it. What would prevent a tobacco advocate, quote-unquote independent advocate, from interacting with these individuals around a particular objective that is inimical to what the legislation is intended to do, on the basis that they have committed no wrongdoing or breached no rules because they are not linked, certainly obviously, to that industry? How would you account for that possible loophole, as I would put it?
So it would be addressed not necessarily in the provision we just went through, but in some of the disclosure provisions, because we also place obligations on public officials and on public authorities in relation to how they themselves interact with the tobacco industry. And I guess a part of it would be how we define the tobacco industry, which is something I think we would have to, again, perhaps reconsider and ensure that it is carefully crafted. But the disclosure provisions, and in fact, when we go further, you'll see that there are actually criminal sanctions in very limited aspects. And it places a duty, for instance, on certain persons to not just disclose, but perhaps even have to divest themselves of direct interest, and so on. So I think it would be addressed from that perspective.
I'm just concerned that the advocacy that may take place may just come from an avid tobacco consumer who may see an interest in that advocacy and indirectly may actually be promoting consumption. And I wondered whether or not, and I said where you're going in terms of preserving rights and balancing and so on, and I appreciate that fundamental principle, but I don't want to create a situation where the industry can find these loopholes to incentivize, encourage indirect promotion, if you will, of the product. And I just wondered whether or not there's somewhere there that could address that, where if there's advocacy around consumption, no matter from where it comes, and it reaches those who are the regulators and the enforcers, then it represents a potential breach or cause for concern or requires automatically some sort of disclosure, no matter where the source. In other words, the source doesn't have to be the tobacco industry or their direct agent. I just wondered how you'd account for that. Mr. Edwards, you want to come in here? And then
yes.
I'm going to go to Member Golding and
Yes, thank you, Chair. As the SG has indicated, there would have to be certain definitions incorporated to give a fulsome understanding of these provisions. The Kenyan regulations do define tobacco industry in a broader way than is proposed in our bill. So the tobacco industry in those regulations are defined to mean tobacco manufacturers, wholesale distributors, importers of tobacco products, tobacco growers, and its associations, and includes other entities representing them, tobacco industry lobbyists, or persons working to further the tobacco industry's agenda.
That's the Kenyan.
Kenyan.
What is ours?
Ours basically is the first part. It just speaks to the persons manufacturing, distributing, importing.
Right. So this is my concern. It's difficult to adopt a piece to suit a particular purpose without looking at the holistic, how it is configured. And what it seems to me that the Kenyans thought about that potential injury, why they created that comprehensive definition. So I would want us to address that as a concern.
Right, which is why I'd suggested, Chair, that you would have to be perhaps reconsidering some of the definitions we have once you sort of settle on the direction.
And Chair, may I also suggest that because of the nature of these provisions being proposed, an option may be to have it in the Act, but some of these provisions may be scheduled or put in an appendix. So it's still in the Act, not separated, but it may be more accessible and more easily understood if some of these details were put in a schedule or appendix to the Act. Thank you.
All right. Should make a note of that. Let me hear now. I'm sorry, member Golden Campbell.
Thank you, Chair. Chair, I have two really short questions, but before I ask my questions, could I just comment on your last concern expressed in relation to the ability of a quote-unquote independent person or entity to reach a public official on behalf of the tobacco industry. And I just want to caution how we, sort of craft for these very, very specific situations. I like the framework of the Kenyan regulations. I think it satisfies quite a bit of the concerns that I had expressed in the last meeting. But, we are never going to, I think, achieve the absolute in any piece of legislation. And certainly when we're talking about how we cull the impact and influence of the tobacco industry. I keep saying this, I've said it before, we stop short of saying that this is a banned and illegal product in Jamaica. And I know that that has all kinds of other implications, but we have sought, in my view, to move as closely as possible as we can to the line without actually crossing that line. And I am a proponent of, well, if that's where we're going, why don't we just go there? But having said that, so where we are, there's always going to be, I think, that room for reach, but we have a legislative framework that does its best to protect us from that. And I say that, Chairman, in the context of this. We are a country of 3 million people. I feel a lot of the times we import legislation and legislative initiatives into our framework that sets in place for us, a country of 3 million people, the kinds of protocols that really only work when you have 200 million people as your population. It's simply not realistic nor pragmatic to ignore the connectivity of Jamaican people through blood relation, through small community, through the second cousin, third cousin, raised by the granny, raised by the auntie. So when we talk about people must, we try to separate and silo, as we're trying to do in this particular provision to prevent the undue influence on public officials. I just want to ask us to be cognizant of the practicality of that and what we are asking citizens to be held accountable for, because some of it is not practical in a small community. So that's my comment. The question that I had, and I'm directing this through you, Chair, to the Solicitor General, is in relation to the regulations, the Kenyan regulations, and I did pull up the Tobacco Control Act of Kenya while you were speaking, SG. Just trying to quickly scroll through it. But was there an overarching provision in the Act itself that grounded those regulations, or was the subject matter solely dealt with in the regulations? That was my first question. And my other question is the provision in, I think it's 22, restricting public officials from accepting offers of hospitality. Does it define what that hospitality offer is? May it please you, Chair.
Thank you, Chair. Thank you for the comments and questions. And just to say, we come from the same school of legal reform that some of us on this side had some of the same teachers, where we don't agree with always taking something wholesale from another jurisdiction and just implanting it here, because you have to consider not just the legal framework, but our own social realities. So this is why when the committee is going through it, not only would you have to then consider the policy of the Ministry of Health and Wellness, but again, how you think it can be applied sensibly into our own Jamaican social conditions. As it relates to the Kenyan regulations, they were grounded by Section 53 of the Kenyan Tobacco Control Act, and in fact, the High Court, the Constitutional Court, considered the issue of whether the regulations were ultra vires the Act and found that they were not. It's a very wide regulation-making power that is in the Tobacco Control Act, which the court found grounded the very specific regulations that were in those regulations.
Steve, if I could just interrupt you. Yes, so 53 was the general regulations power. My question was whether or not the subject matter was at all treated with elsewhere in the Act, and these regulations were made pursuant not only to 53, but to some other provision that it was now setting out details for, and I'm thinking your answer to that is no.
No, right, no. So this was the regulations, and these specific provisions emanated from the wide regulation making power. So again, a different structure than how we have done crafted our tobacco control legislation, because I know that we will still be doing regulations, but we still have quite a bit of detail that we will have in the Act. And just as an aside, the suggestion made by Mr. Edwards is something that the committee should really consider, whether you want to put some of these matters in the text of the bill, or if you want to put them, for instance, in a schedule, because you may want to have an easier mechanism to amend some of these provisions. And if you put it in a schedule, that gives you more flexibility to be able to amend them as you go along. I was also looking at the fact that there is a review provision of this bill, and I think it's a 4-year review. So when we pass this, everybody loves to say we're not going to pass a perfect law. Well, that goes without saying. Things develop over time, so you also will have that review mechanism to assist once the review does happen within the 4-year period. But you perhaps would want to think of grouping some of these matters and putting them in a schedule, which could assist you with an easier mechanism for amendment.
Thank you.
I think I forgot the second question, Senator Golden.
Yes. The last question was about whether or not the offer of hospitality was defined.
Yes,
but
no.
I apologize too, because I left out one of my more important questions, which was whether or not there were penalties. What's the nature of the penalties for breaching the non-disclosure provisions of the regulation?
So there was no criminal sanction for the provision I just read, which is a limitation. Thereafter, there are some penalties that I can take you to a little later on. But their penalties are generally, their general penalty is a fine not exceeding 500,000 shillings. I'm not sure how we convert. I think a quick Google search may assist. Or to imprisonment for a term not exceeding 3 years. That's their general penalty provision in the regulations. But this particular provision was not going to lead to a criminal sanction. The hospitality is also something I had a sort of question mark about. So the way it's used, you would basically go to ordinary meaning, what the dictionary meaning of hospitality. It perhaps may be a little too wide, and I think it is something that perhaps the committee would want to consider. If you're going to retain it, whether you want to still use the term hospitality or you want to make it a lot more specific, less vague.
Let me, go ahead, Senator.
Thank you, Chair. There were some of us who found 8, 9, and 10 to be very intrusive in nature and very aggressive, exposing the public officer to punitive actions. And this approach, in my mind, is what I would consider a softer approach, a more delightful approach, if I may say. And I view it as more of guiding principles. I like 22.2 that speaks about the two public officers, which gives dual custody, dual accountability, not one. The other can witness for the other. I have a concern, however, in terms of we have to define what interaction means. And the question of the public space or public venue, if we are going to incorporate that. 22.3, before commencing any interaction with the tobacco industry, the public officer shall state in writing that the interaction does not imply any endorsement of tobacco industry practices and so forth. So that's a protection, a declaration on the part of the public officer. What I'd want to ask is whether or not this requires some sort of a response, acknowledgement from the other party to which it's being written to, or is it just a standalone declaration? And I, too, also have the concern in terms of the failure to abide in terms of these guiding principles. What would be the recourse? So those would have been my observations, Chair.
All right, do you want to comment, SG?
Well, just to say that I, as it relates to 22.3, on the face of it, it just says that it's a statement, a declaration that would be made by the official. I would say best practice would dictate that it also be countersigned, but that's not required under law. What is required under law? Just that that statement be made. So it's really more a protection for the officer, that the officer could then rely on it at some later stage to say to the tobacco industry, look, when we had that interaction, it was not any sort of an invitation to treat, so to speak. It wasn't an offer. We weren't making any kind of offer, and this is something that I can rely on. But as I said, I do think it could be enhanced. I know you asked something else. I'm sorry.
All right, I see Senator Allen. You want to make your comment or question?
Thank you. Yes, thank you so much, Chair. Good morning, all. SG, earlier in your, as you were making your comments before going into the details of what is being proposed, you made mention that there was a concern or reference, you had some reference to other legislation that would govern other industries like alcohol or the cannabis industry, and that what was being proposed originally in what we've been considering was almost counter to or not in line with what exists in those other pieces of legislation. My question is, if we were to adopt with edits, of course, as we've been discussing, what is being proposed here as with the Kenyan legislation, would those insertions or changes be in line or still counter to what exists in for the alcohol industry or the cannabis industry? Should we be seeking, maybe not under what we're doing here now in the remit here, but should we seek to align in those other pieces of legislation, or do you think there's anything to be concerned with?
Okay, thank you, Chair, through you. Thank you for that question. Actually, there is no similar restriction in terms of interacting, limiting the interactions of public authorities with those other industries. And that is the reason it raises issues of equality, equitable treatment by a public authority, and in fact, that was part of the issue that was raised before the Kenyan Constitutional Court, the fact that there were other industries that were not being asked to restrict themselves in the manner in which the tobacco industry was being restricted. And part of the answer to that, and that answer really came from the Ministry of Health and Wellness, and it's actually even throughout the bill. It's the intention, the rationale, why do we need this law? And that is part of how you would answer why you need to limit the interaction between public authorities and the tobacco industry and justify this kind of scheme here as opposed to, and to explain why you need it here and not elsewhere. But I'm not aware of this applying to any other industry.
We have Member Guy and then Member Longmore.
Thank you, Chairman. SG, Clause 8 of the bill, and by extension 9 and 10, have always, as Member Gale had indicated earlier on, been the source of some discomfort with the membership of the committee here. And I do recall on one occasion the AG, then AG, who was a member of this committee, spoke about the constitutionality of especially Clause 8, and that it would infringe on the constitutional rights of some persons. My question to you is, would Clause 8 in its current dispensation, as per the bill here, could it be a reason for a challenge in our local court, the constitutionality of it? I see where the Kenyan position is, and I suspect where you're going in terms of bringing this out, in that it went to the Constitutional Court in Kenya. But in terms of our Chapter 3 of our Constitution, would Clause 8 be one of those provisions that could be challenged in the court based on what it says here?
Thank you, Member. You will recall that we had actually provided an opinion dated July, I think, 13. And in that opinion, we had concerns about Clause 8 and Clause 9. We did not provide any comments as it relates to Clause 10 because the issues we have with Clause 10 are slightly different. As it relates to Clause 8 and 9, we had concerns about the constitutionality of the provision. And what we had requested from the Ministry of Health and Wellness, which they provided, was a rationale, because we did not feel that we were in a position, we did not have enough information to be able to defend the structure of those provisions. So the Ministry of Health and Wellness did provide the rationale, the basis, but again, we are still of the view that it needed some more attention, because we thought the vagueness, to an extent, the fact that it was not specific in how it addressed the limitation. So, for instance, both public authority, public officer were being treated in the same way. That would not have been able, we would not have been able to demonstrate that careful design and the minimal impairment of the right. And this is why we are we're more confident with the structure of Regulation 22 in the Kenyan regulations, that it does answer some of those issues that would have arisen for clauses both 8 and 9.
And I share what the 10-minute Busher said, chairman said, in that we feel more, I certainly feel more comfortable with what is proposed here. As to how Mr. Edwards and the team will integrate it in what we have is another matter. But I'm happy that this gives a more reasoned balance to what we're trying to have here, whereas at the same time not contravening what we have signed in the convention.
And again, that same constitutional court considered the WHO Framework Convention and the guidelines, which are part of the reason they would have also had that framework. So again, the rationale for them is pretty much similar. There are some concerns they had, which is perhaps why they went a little further in some of the disclosure provisions, and we'll get to that in a little while. But the basic reasons they needed this law, are basically our reasons as well, and would be able to be presented to a court to show the reason you need it.
Member Longmore, you had some concerns too.
Thank you, Chair. We had raised a concern regarding Clause 9, and I'm hearing the deliberations and the suggestions, SG. I am wondering if it is being addressed, and maybe because I wasn't at the last meeting, etc., but the Kenyan suggestion here in terms of regulations, the interactions between public authorities, public officers, and the tobacco industry. In Clause 9, the concern that we had raised was, we as in the JPA had raised, was in reference to the level of employment that would apply to Clause 9, where restrictions would be. So let's say now the Kenyan law obtains for the higher functioning officers and the managers, etc. But our concern was around probably the persons who are not so much in the decision-making capacity, but still employed in the industry. So a janitor or someone who is of another level staff who may choose to invest on the stock market to further their financial interests. Would there be any liabilities? Does the Kenyan law obtain to that circumstance to protect or penalize those persons?
Yes, so part of that would be addressed with the disclosure provisions. So there is disclosure required for all public officers, but just different levels of disclosure. And for instance, for those who are involved in either making policy or defining policy, they are actually even required to divest themselves. The other persons have to go through our disclosure regime.
So at any level?
At any level.
So even if, like I said, it's a member of the janitorial staff,
once you're a public officer,
once and employed, that person has to disclose and is restricted from any interaction with the tobacco industry.
Yes, and they even have a provision to say if you are not yet employed, but you are applying and seeking employment, you would have to also be aware and make that disclosure early on.
I think, Chair, well, it will go for further debate elsewhere, but I think we might want to reconsider in terms of the level of employment. To penalize someone who may not be in a decision-making capacity in a way that they may be financially trying to better themselves, I think is something that we may consider. But thank you for the clarity.
Soldier, may I ask if this is what is being contemplated in 23.1?
No, these were in, well, let me 20. Right, yes. So the disclosure is in, so that starts in 23.1.
Starts in 23.1.
It starts in 23.1. So there are other provisions that are geared more at those who are operating at the higher level, those who make policy or help to form policy. But 23.1, it just talks about a public officer, which does not limit. It doesn't say what type of public officer. It's just general. So these are things you would have to again consider to see if this is what you would want. I did a little background reading, and I noted that there had been some issues in Kenya relating to corruption, it appears, between public officials and the industry. I'm not sure at what levels that corruption was, but that was also something that the court took into account in considering whether the framework went too far.
Are you referring to 143 on page 2?
143.
It says in my view, it is within the mandate of CS Health to make regulations that will limit interaction between such an industry
Yes, correct.
and public officers who, unfortunately, a matter that is within the public domain, are not famous for their integrity and concern for the health of the public.
Yes, correct. And that was something that was taken into account, because you always are going to look at, a court will always take relevant situational issues into account when considering how a law is designed for that country. So again, these are things that you would have to wait to see if really Jamaica should go this far. Now recall that the policy of the Ministry of Health and Wellness was to deal with these types of matters aggressively and to ensure that persons would be held to account. I think the issue is, how far do you go?
So based on what Member Longmore had raised in terms of those at a particular level of employment maybe investing in these entities, now your recommendation is to delete 8, 9, and 10, which would take that away and substitute it with these recommendations. So we now would have to see what that proposed recommendation would look like.
And can I just say as well that part of the Kenyan framework is the fact that they have what's called the Public Officer Ethics Act, and we don't have that. So again, to me, we would have to be mindful of that regime and understand that they would therefore be going perhaps a little bit further than what we would want to.
Public officer what?
A Public Officer Ethics Act.
Oh.
Which again is something where you have a disclosure. It deals with conflicts and how you address them for public officers, and has different sanctions in them as well. But some of what is here is consistent with that framework that they have. So it could be that you would want to consider whether we need to go as far as they have or not, noting again their own internal issues in Kenya.
That is where, Soljan, so what they have in place is relying on another piece of legislation. But we don't have that reliance. We don't have the opportunity to rely on any other legislation that would support this.
Okay, to an extent. So we do have, for instance, corruption legislation. But it's not quite the same as like a Ethics Act, for instance. Not quite the same.
Because for this is applying guiding principles.
Yes.
But the corruption legislation is more egregious in nature.
Right.
And so the actions might be more punitive.
True. So for instance, one tweak, if we got to Regulation 23, one tweak that we discussed, and I know Mrs. Celia Brown had suggested, if you look at 23.3, where it says a public officer having made the disclosure shall subject to, and it references their Public Officer Ethics Act, they should not do a number of things. Now, when you look at the things they're not to do, these are things we think should also apply here. But granted, it is true that it is done within the framework of another piece of legislation they have. But, I mean, for instance, you should not be present during any interaction of the public authority with the tobacco industry. If you know you have interests, you have some interest in the tobacco industry, you should not take part in the decision making. I mean, these are things that you can understand should also apply. However, what you may now say is perhaps you wouldn't want you wouldn't want it to be a criminal sanction. Because you see, their criminal sanction, again, is based on the regime they have with that Public Officer Ethics Act. So to me, these are things you could take into account in deciding what you want to apply and what you don't want to incorporate, and the extent
Okay.
to which you want it to apply.
Thank you very much. Apologies for my short absence. But I see Senator Allen hand up. You want to make your comments, and then I'll.
Yes. Thank you, Chair. Just one, in following up on what Senator Longmore made mention, and she's indeed correct that this was an issue that many of us had in relation to the level of employment. Could it be that if we were to proceed with what is being proposed, that it is simply, it would be a matter of the definition of a public official or public officer that would then remove the concern relating to a janitor, for example, because I don't believe that there's any reason to believe that we should be having that level of concern, and therefore it could be addressed with a definition of public official or public officer based on what is proposed.
Yes, that could be one way, or for some of the disclosure provisions in Kenya, they actually talk about the public officer who has a role in setting and implementing policy. So you could also frame it that way to exclude certain persons. It's just that they would have had 23 as a wide provision because of their Public Officer Ethics Act. And I think that is the reason they would have had to cast it in that way. And we don't have that framework. So, I mean, the decision is whether you want to cast it that wide or you want to limit it in the way that they have limited other provisions to talk about those public officers who have a role in setting and implementing public health policies with respect to tobacco. But I think
I could go with that.
Okay. Yes.
Chair,
Yes. Ms.
you want to go ahead?
Just a clarification, SG, is it that from what Kenya is saying, everybody who has an interest must disclose, but you will only divest if you are implementing policy, if you're directly involved in enforcing or implementing policy?
So that's what I had said before.
So, okay.
So I had said that before, and I think there are different levels of disclosure and different obligations that go with the levels of disclosure, depending on your position. But I think there's still a concern even about 23 and the fact that all public officers would have to make this declaration or disclose, and the fact that in Kenya they would be subject to a criminal sanction. And I'm saying I think it's cast that way because of their Public Officer Ethics Act, which we don't have.
All right.
Another thing, Chair, when you look at the Public Officers Integrity Act, to which Regulation 23(3) is subject to, that provision, Section 12, it's actually a conflict of interest provision. And we have similar provisions dealing with conflict of interest in our, and in this legislation too, so you may even want to link it to that provision, tweak it. We can look at how they've done it in Kenya and we can tweak it, and then we can link it, Chair, to that whatever we have in this in the tobacco industry legislation, create that nexus.
All right. Can I just, and I take it I've missed out a little of the conversation, but let me just summarize a little, because I think we need to move on. It's clear that we need to work out some more better particulars on a couple of issues. Mr. Edwards, having accepted in general the principle that is being advanced here, I think it's important that you weigh in on the conversation, if you will, to narrow the focus a little more around some of the specifics. And my issues here, and I can be complemented by others, would be the issues around penalties. I think we need, I don't know how you deter if there isn't something that promotes the deterrence. I mean, if it's what is a scolding, you want to comment on that?
I want to point something out, because I see you're going down that road.
Sorry?
That the 23 that Saljan is referring to has a subsection 3, and that subsection 3.
Oh well, that wasn't said earlier. So now
that 3 limits that individual who has been required to make the disclosure. They mustn't be present during any interaction of the public or authority with the tobacco industry. They mustn't take part in any decision making.
So that's,
and if it is if any of these things are contravened, it's an offense.
So this is the point I'm making. So that's why I say we need to now create some clarity around that. Huh?
Whilst there is an indication, a very strong indication, that you ought not to do certain things, and that is defined here, what we're not clear on is if you don't abide by it, what happens?
This is where I was going.
No, but what's the penalty? Oh,
Right,
so are we to take it then? Are we to take it then that yes, we're going down this road. It is likely that we're going to accept these recommendations, not in its entirety, subject to some amendments, but you'll guide us in terms of what those proposed penalties would be.
This is the point I'm making. This is exactly the point I'm making. Hold on, Mr. Edwards, because time running on us. I want to just make the point. I have two other things to say. So that's one, which I think needs to, I'd love to see a proposal that suggests exactly what that means. The second one is a definition of involvement and interaction, because while I appreciate what Member Golden Campbell said about the wholesale adoption, and I'm fully into that, I believe we have to be contextual, I think that the definition by the Kenyan legislation around who constitutes to capture everybody,
industry,
to allow, to plug the loopholes of the lobbyists or the, I don't know what you call them in campaign terms in the US. You call them, there's a particular name for them, right? That kind of escape out of the net because they are quote unquote independent. We have to capture that. And I think our definition would have to be adjusted, Mr. Edwards. I don't know if that does any injury to the rest of the bill. I need to be advised on that because normally when you change one thing, it affects. So we need to clarify that. But I would be comfortable if the definition was more all-encompassing and align it to what you are suggesting. The third is the hospitality, clarity around that. You know, I tell you, I don't know if you want to be too specific because I think you can offer hospitality in so many ways that you may need to look at a case by case to make a determination on that, and so I'm almost tempted to keep it as is. And if you have to define it, you define it in a broad way. And then the fourth one I have before I stepped out was the issue of the review clause. I fully appreciate and support that. I think we really should have a review clause for the legislation. I don't know if it's 4 years or 5 years or whatever. 4? Yeah, 4. Okay. So I don't know if there is anything else that was mentioned in my absence that may require further specifics. But what I was going to ask is that we lock those in for the teams to come together and then maybe come back with very specific for us to accept as we move to the next level, and then we move to the next clause. Was there anything else that would have been required?
Well, Chair, sorry, just to say, though, that you do have a few members that don't like the wide application of the Regulation 23 in Kenya, which applies to all public officers. So we would perhaps need some guidance on that, because 23 is saying that all public officers, notwithstanding your rank or level, must make a disclosure.
If you are involved in...
No, it just says a public officer who has any interest, whether pecuniary or business interest, in the tobacco industry shall disclose the nature of those interests.
That involves having some shares, or...?
Yes, for instance, yes. Whereas you do have other disclosure provisions that are tailored to public officers who have a role in setting and implementing public health policies. So I do know that a few of your members have expressed concerns with the wide application of Regulation 23. And I was trying to explain that I think the reason that was there was due to that Public Officer Ethics Act that they have.
Any comments on that? I have a particular thinking, but I'll probably.
Mr. Chair, my view is that I would want to see a definition of public officer or public official, and stay away from the wide reference that is in 23.
My view.
Thank you, Chair. I'm in agreement with Senator Allen for the clear distinction of what is meant by that influential officer. But also, just to quickly add, Chair, in terms of the 4-year review, just being a bit practical and effective, we have legislations that are a lot more technology affected. This is not one of them. I would actually expand that review time to be realistic that we don't miss it. And I would say between 5 and 7 years, my suggestion.
Okay, but the review time doesn't bar an earlier review if necessary. Yeah, so maybe you could do 5 years. 5 years.
4
I mean,
years, leave it at 4.
Remember saying leave it at 4. I mean,
I agree. Leave it at 4, Chairman.
who said that? Oh, Senator Allen.
Janice, Senator Allen, yes.
Unfortunately, you're outnumbered today. Member.
Oh man.
All right. No, let me get back to that. The issue of the public office and the definition. So I do agree that some public officers may unknowingly have an interest in the particular industry if they are a part of a group pension fund, or they have their financial advisor managing their affairs and buying into sort of a set of stocks, etc., etc. And that could be problematic and create an unnecessary burden. Is there a distinction, though, between a public officer who promotes the consumption of knowingly versus one who does not? And whether or not that could be the kind of narrow distinction, thin line, I don't know. What's your thoughts?
The distinction is really those who have a role in setting and implementing public health policies with respect to tobacco control. So the outside of this very general provision, the others are way more tailored to public officers who are involved in developing, implementing policies.
So you're saying we could keep it at that? Because
I
it
just
becomes
wanted
clearer.
to point out one other thing with the wide 23, that the disclosure it's either on the commencement of employment or as soon as relevant facts have come to your knowledge. So I think that last rider, where the facts come to your knowledge, that you would be able to say, I wasn't aware that I was a part of a pension plan and that the investment, one part of this investment portfolio included owning shares in the tobacco industry, because I am aware, that you do have some employees who don't know how their pension plans are being
Well, that's the point.
invested.
That's the point I was making.
But this speaks about when the facts come to your own knowledge as well.
Right.
Sure. Not to belabor the point, but it is that important. I just looked up regularly the definition of public officer, and it says a person who has been legally elected or appointed to office or who exercises governmental functions. I think that actually clarifies the whole issue, because I have an issue with where it is defined as persons, governmental persons or such, who are only involved in the tobacco industry. Because let's say somebody is appointed in the Ministry of Agriculture, and they have that level of influence. They can still impact on the tobacco industry, but they're not directly employed there.
Which is why we spoke to the definition
Yes,
earlier.
so, just
And I think we're agreed.
I think we're
agreed.
clear that that we have a distinction, and it wouldn't apply to certain levels.
Okay.
Chair?
Go ahead.
Yeah, thank you. The only concern that we would have from the perspective of the Ministry of Health is that yes, we do appreciate the need to separate those who are involved in the settling of policy or the setting of policy from the wider public service. But in implementing Article 5.3, there is still the broad obligation, and I think this applies to things like staff orders, public service regulations, that speak to the broad code whereby public officials in relation to the tobacco industry, there should be standards relating to how everybody in the public service deals with the industry. So you're going to have different obligations for disclosure, divestment for those setting policies, but there is a general principle under the convention that speaks to how public officers...
And I'm inclined to support that. I really am inclined to support that, because I do believe that there are allowing some to be allowed a free rein or freedom to act in any way they want around this particular situation could create some leverage for the tobacco players to pursue their interests, because those interests touch down not necessarily because of direct involvement, but based on points of influence. And those points of influence can emerge from all sources in different areas. Right? So I do think that there needs to be some sort of all-encompassing provision around the motivation and the deliberateness of the pursuit of the particular goal which we're trying to discourage. You understand what I'm saying, Madam SG?
Yeah, yes, but I just wanted to remind members that there was actually a proposed definition for public official in the draft amendments, which would basically include any person employed to a public body.
That is pursuing. That is
no, or performs. No, it wasn't limited in that way, in the way you're now explaining it, Minister. So I'm just saying that we would then perhaps want to have to tweak it to address what you're now saying.
I think motive is important. I really do think motive is important. So whatever definition you use shouldn't just be about any person. It has to have some levels of premeditative deliberateness around the issue. If you have another view, Kilian?
Thank you, Minister. To follow on Mr. Edwards' point, I think it is important that we take into consideration or recall the intent of Article 5.3 and in terms of application to all public officials so as to limit any possible interference from the industry. And in reviewing this section to design a scheme which, sort of scales it in terms of, as it has here, disclosure in the first instance for all, and then perhaps more strict requirements for persons who are directly involved in policy making or decision making.
I may have miscommunicated. That's kind of what I was saying. I mean, that was where my thought process was. But maybe sometimes I speak and deviate from my thoughts. Not a good thing.
Sorry, so Chair, then I would have to reiterate my caution then, which is if we're making it obligatory for all to disclose, then you really have to consider the application of the criminal sanction. And that has always been an issue that I've had. And again, the framework that you have in the Kenyan regulations, and I know it is still subject to a number of matters such as you should not be taking part in decision making, you shouldn't be present in deliberations. I still think you have to be very careful when you say you want to apply that criminal sanction, because you have another option. If you're looking at public officers, you can do a disciplinary sanction.
I thought the follow-on to what Ms. Burge said, that you would apply different punitive measures depending on the position of those public officers, would have addressed that concern, wouldn't it?
Well, we would need to be guided by what the committee is thinking.
And before Mr. Edwards goes Chair, I am misapprehending something. Article 5, what does it say about public officers and involvement in the tobacco industry? Can somebody tell me before I ask the question?
Okay, well, looking at the guidelines, so we have a number of steps. The first, a number of principles in relation to public officers specifically. All right. The whole intention is that we are to restrict industry interference in public health policies, establish measures to limit interactions with the industry and ensure transparency of those interactions, reject partnerships and non-binding or non-enforceable agreements with the industry,
So it's-
avoid conflict of interest for government officials and employees, require that information by the tobacco industry be transparent and accurate. So I think the specific point is avoiding conflict of interest for government officials and employees.
And to
And
limit.
to limit interaction.
So it doesn't say you're to obliterate.
No, it's a
Right.
control.
So basically, the scheme, Chair, that Miss Cady and can answer the last part of her name, Birch, suggested in different levels and different approaches in terms of disciplining, whether it's offense or staff orders, regulations in terms of punishment, is the route to go.
Which is what I was saying. So can you put that to the list of 5 things that we may need to just specify and come back with specific recommendations? Mr. Edwards, you'll have to triangulate the conversation over the next week. All right, can we move on from this one? I mean, it's 10 minutes to 12. Do we have time to run through the next one, SG? And maybe see if we can solve it before we close. Really.
I think
Chair.
I heard Mr. Edwards.
It was just a technical point, Chair, that in light of what we're discussing now, and the options being, for instance, putting some of the provisions in schedules or appendices to the bill.
I want you to come back with a proposal on it as
Okay.
to what you recommend. We can have some internal discussions on it.
Okay,
But I don't.
okay.
Let me tell you, when we come here with the open-endedness, we never make a decision, and we have to make some decisions. Remember, we have a review process, you know.
Yeah.
So we're not going to allow good to be the enemy of the perfect. Otherwise, we'll never get anywhere.
Yes.
So what I wanted to do is to come back to say, based on my study of the matter and consultation with the colleagues, we recommended this goes into that area, this
Okay,
goes into
sure.
that area. And then just come with it and we tweak it and agree on it, okay? All right. Any other quick comments on this? Otherwise, I'm going to ask SG to just quickly take us through the next area on her. You have anything else to add?
No. I was going to say, the committee had basically looked at Regulation 23. I just had a quick comment, though, in terms of like the definitions. The definitions for the Kenyan regulations were specific to the part dealing only with the interactions between the public officials, industry, and the tobacco industry. So it wasn't of general application, and perhaps that may be the way for us to treat with it, that if we put in definitions, for instance, that deal with lobbies, and so it could be tailored only for the part that deals with, or schedule that deals with the interactions, and not for general applicability for the bill itself. So I would just quickly read Regulation 26. A public officer who has or had a role in setting and implementing public health policies with respect to tobacco control shall A, inform the respective public authority where the person served about any intention to engage in any occupational activity within the tobacco industry, whether gainful or not, within a period of at least 3 years after leaving service, and B, not engage in such occupational activity within a period of 3 years from the time the person ceases to be a public officer. So a cooling off period. I don't know if that is something that you would want for our jurisdiction. Again, there are situations in Kenya that perhaps required this. I'm not sure that this is something you'd want to apply here, but something to consider. 27, a person applying for a public office, so this is persons who are not yet public officers. A person applying for a public office which has a role in setting and implementing public health policies regarding tobacco control shall declare any current or previous occupational activity with any tobacco industry, whether gainful or not. 28, a public officer who has a role in setting and implementing public health policies with respect to tobacco control shall declare the interest in the tobacco industry to the Cabinet Secretary and divest himself or herself of direct interest in the tobacco industry. And to me, this would, for our purposes, would be someone like a minister, perhaps the permanent secretary, someone very influential and at the top level of the hierarchy, so to speak.
Chair.
Go through the rest of them and then we take the comments after. Yeah.
31. 1. Any entity which is part of the tobacco industry shall not grant any monetary and non-monetary payments, gifts, and services to public authorities or a public officer. A public authority or officer shall not receive any monetary or non-monetary payment, gift, or favor from the tobacco industry. 3. A public authority or officer who contravenes this regulation commits an offense. And the offense, again, is the fine not exceeding 500,000 shillings or imprisonment for a term not exceeding 3 years.
I wish you had come here with the interpretation of 500,000 shillings, but okay, we'll work on it.
Yes, somebody can just go to
It's
Google.
120.
We'll work on it. We'll work on it. It's okay. Huh?
It's
4,000
120 shillings per US dollar. So it's
all right, go
roughly
ahead.
about 4,000.
Go ahead, Madam Minister.
Okay.
Just giving you trouble.
32, a public authority shall not grant incentives, privileges, benefits, or any other preferential treatment to the tobacco industry to establish or run their businesses. So those are the provisions that we highlighted for consideration by the committee.
Okay. So we can take comments now, if I may. I think 26. I wonder the validity of 26. I don't know. Maybe I'm missing something.
My concern with 26 is around an involuntary separation. If you terminate me, it means I can't take up or I have to inform of my association of any involvement with the industry. And I think that places a great degree of burden on those individuals who would have been separated involuntarily. If you volunteer to leave, that's a different situation. But if you terminate me for whatever the cause, for whatever the reason, and it may be even redundancy, then I have this obligation. And I think that's a burden that I don't believe that these officials should be saddled with.
And perhaps you would also want to consider, sorry for jumping in, Chair, but since we're running out of time, the other situations where you have cooling off periods. We don't utilize it a lot in our legislation, and sometimes we will have it applying to, let's say, persons in very sensitive areas, like for certain security officers. Let me put it generally like that. And it's not something that we readily apply because you'll recall Senator Golding Campbell speaking about our Jamaican context, how small we are. I mean, 3 million, it's tiny. How we all interact, how you look at gainful employment, and whether you really think there is a mischief we really have to attack or address by having a cooling off period. So those are the considerations you would have to take into account in determining. It could also be that you have a cooling off period, but you reduce the time.
My understanding of cooling off period is normally associated with competing interests, like a business is sold and you don't want the person who sells the business to go next door and open a similar business, taking away the customers and that sort of thing. I'm just wondering if you declare, having left government, for example, that you're going to work with the tobacco industry or the alcohol industry for that matter, what would be the injury there, unless you're taking some top secret or across trade secret, or I mean, I don't know. I mean, somebody probably can help me to understand it a little more. But on the face of it, I'm not sure what we're trying to prevent.
Yes.
Yes.
Sure.
Chair, if I, oh, I'm sorry. I didn't know.
Well, you can go first.
All
And
right.
then Mr.
I
Edwards.
just wanted to clarify in support of Seljan. It is the person who had a role in setting and implementing the policy. When that person leaves, the idea is that that person now shouldn't benefit. If some aspect of the policy had a loophole, for example, they would be even more keenly aware of it. They would go into the industry and inadvertently benefit from the very policy they were a part of setting. And that is why it is there.
Okay.
So it's important.
Okay.
As Sergeant said though, if 3 years is too long, you may consider a shorter period. But I think it's an important provision.
Okay, I hear you. Let me hear you, Mr. Edwards.
Well, yes, just also in furtherance of that to indicate that a number of the provisions that SG just read from Regulation 26 Kenya are actually restating the guidelines of Article 5.3. So they're really restating the guidelines from the Framework Convention. And that issue of the cooling off period is stated at recommendation 4.4, which says that parties should develop clear policies that require public office holders who have or have had a role in setting and implementing public health policies with respect to tobacco control to inform their institutions about any intention to engage in an occupational activity within the tobacco industry, whether gainful or not, within a specified period of time after leaving service.
Okay, so you're saying that that is a sort of universal clause, if you will.
Yes, they were seeking to really mirror the requirements under the FCTC.
Any other comment from members of the committee?
There are two aspects to it. One, in the first instance, to inform. So you notify. But in B, not engage. And that's where I'm having the concern, not engage. Now, the cooling off period, we might want to seek to reduce the cooling off period as it relates to not engage. I don't have a difficulty with to inform, you know. There's no challenge with informing. But to not engage, maybe we can examine whether or not we can reduce the cooling off period for the engagement.
Any other comment? May I ask Paho to come in here, maybe give a comment on this?
Thank you very much, Mr. Chair. I think that, as Mr. Edwards had said, the Framework Convention is actually quite clear on the intention here, and I think that what we're trying to talk about is the reduction of influence, right? Because we know that the people that have been a part of the policy are part of the discussions within government, within the bureaucracy as well. And so when they move to outside of government, they go with all their connections and all their influence as well. And so that cooling off period is a very important piece to reduce the impact of, as I say, influence. Typically speaking, those are usually 3 years is the standard. And I would also say that there's typically a reciprocal thing as well, which is people who are in the industry should have a cooling off period before, if they are inclined to join the public service as well.
Well, are we agreed?
I am agreed with the cooling off period, Chair, but I think it can be reduced to 2 years.
2 years? Okay. I mean, I'm not. What's your thought, Senator Longmore?
I think it should go with whatever obtains in other jurisdictions internationally. I think that might have implications in other respects. So I think we should align ourselves with that. 3 years.
Anybody else? Okay. All right. Since I'm the tiebreaker, I'll go with Senator Longmore at this point in time. So let's keep it at 3 then, in the interest of a decision. How is that?
Question: if this is a practice anywhere else in the public service?
You mean for other industries?
Yes. So for other industries and for this public official, Is it practiced anywhere else? Is it a standard?
Go ahead.
Oh, so this is what I said earlier about what I'm aware of in other legislation dealing with, I think, security forces. It's not of general application. It's not of general application.
Yeah, but I don't think that you can use the tobacco industry in terms of this kind of general application, because I think we concluded early in the day that the tobacco industry is like any other. And that's a real issue. But let me hear what Paul has to say.
Thank you, Mr. Chair, and thank you for the question that you're raising here. Is I think that it's important to recognize again that the tobacco industry is particular because the Framework Convention of Tobacco Control and the signatory of Jamaica to the Framework Convention on that particular industry. And so I wouldn't be surprised if there's not other examples because the government of Jamaica has not signed other treaties in the same respect.
Yeah, that's my thought. Senator Allen, you want to quickly come in? We're going to try and finish off with this document as we had committed. So I know we're over a few minutes. Please indulge us.
Thank you, Mr. Chair. I just wanted to clarify the comment that was made earlier by one member of the technical team that we are speaking here of persons who are directly involved in the development or formulation of policy, and therefore we're speaking to a very specific group of persons, and so this is not necessarily something to be generally applied, correct?
That's my understanding, right, SG? And the bill will reflect.
Yes, I didn't make the comment, but that's correct.
Okay, yes, you're correct. All right,
okay, so
if there are no other...
I'm quite satisfied with the brief.
Okay, great. So if there are no other comments on that, the decision is to hold. The others, I think, are fairly straightforward. I don't know if anybody wants to comment on the other clauses, 28, 31, 32. Is there any issues at all with any of these? Gifting and so on. These are fairly straightforward, aren't they? Yes, Ms. Dennis Wright.
Thank you, Chair. Just to add that a lot of the provisions, we recognize that the guidelines are instructive in the development. So I hear earlier the indication that perhaps it was based on, or some of these provisions may have been influenced by what was happening in Kenya. That might be true. However, when we look at it, some are very much based on what the guidelines provide for. So although the convention is clear about Article 5.3, the guidelines, being the consensus documents, have clearly outlined and given examples as to how these can be reproduced, and we have seen similarities where this is concerned in the Kenya legislation.
Right, so you're saying the guideline has guided Kenya, and we are being guided by the guidelines. But we still have to contextualize, right? So even so, we have to make it relevant to our dispensation and our constitution. But I think we have made progress. I think that the difficult,
Chairman,
yeah. Yes, Senator Allen.
One last one. In 28, just to clarify too, that the cabinet, the Solicitor General was suggesting that the declaration could be made to the permanent secretary or the minister as opposed to the cabinet secretary? Or were we speaking only of those levels to declare themselves to the cabinet secretary?
What's the
Well, actually, that's a decision that the committee will need to take because, for instance, this could include a minister. So who should the minister declare? I think that is something. So Senator Allen is correct. I'd said, depending on the level, so if it's a director, senior director in the Ministry of Health, then it could be the permanent secretary. Or if it's not within the ministry, to their senior supervisor. But for instance, the minister, who would that declaration be to? And also there was, to me, I thought that there needed to be something else in 28 because it says you make the declaration and you divest. It doesn't say when. And I think you also have to be mindful that, someone who has, let's say, a stock portfolio, you can't necessarily, it may not be so simple to divest yourself immediately because of how your portfolio is, for instance. So I think those are things you may want to take into account, but I found that this was a little bit vague in terms of when it would happen, when the action would happen. So I would have said, for instance, the declaration should happen promptly. The divestment would have to be negotiated and discussed, and there could be a determination around that, because I think you need more flexibility in terms of the divestment. But that's just my own personal view.
Okay. Mr. Edwards, do you have any comments on that?
No, Chair. No, I don't.
So what I'm proposing is that those comments are incorporated in the list of 5 to bring some specifics to the next meeting, so we can either accept or tweak the specifics. Madam SG, working, of course, Mr. Edwards will drive that process in terms of the specifics, the definitional stuff, and so on. And then what I do at the beginning of that meeting, next meeting, is to just read them out so we can accept or otherwise, and just kind of finish this aspect of it, and then move on once we can complete in time through additional items like the definitional terms and so on. Now, what we would have to do then is accept what is recommended here, which is to delete clauses 8, 9, and 10 of the bill in light of the proposed replacement. Am I correct? Right. So we need the committee to. Okay. So I hear a formal so move and seconded by Senator Gale and seconded by Senator Longmore. Unless there's any objection to that, we will accept then that we replace what hopefully we will finalize next week. Replace 8, 9, and 10 of the bill.
Chair.
Yes.
Are we also suggesting that we put them in the schedule?
I think that's going to be a conversation that will take place during the course of this week in terms of whether we go schedule or in the main legislation. So Mr. Edwards is going to have some consultations, look at where the precedent exists or contextualize to our situation. I think what SG was saying is that in our case, we have been fairly detailed in the main body, the main legislation, as opposed to Kenya, which put a lot of the details in the schedule. But given that we have a precedent for specifying, we probably could put more details there, even though, according to what you have said, it gives us more flexibility for adjustment if we put it in the schedule. I like the flexibility because I think these things are always going to be subject to review. So it's a matter of deciding what goes where and agreeing on that.
Another advantage, Chair, of having scheduled material is that we're likely to be having definitions that are just going to be specific for particular purposes. Okay.
Okay. So
Chair, if you could just allow me one small comment. Ms. Auld Googled, and the shillings, it works out to just about 630,000 Jamaican dollars, which actually, though, is not in keeping. I cannot answer that. I'm not going on that road.
We had said 4,000 US.
But the custodial penalty is not in keeping with the general formula that we have, which is usually $1 million a year, $500,000 6 months, and really the fine works out to about 630,000 Jamaican. So the 3 years is a little bit out.
I wouldn't place too much stock on that.
Right. So I was just giving
right,
you what
yeah.
they have.
We will align that to our context. So that's what I would recommend.
Yes, I think we would want to make it in line with the other penalties we already
right.
have.
Yeah, understood. All right. So thank you very much. Can I go to any other business? Any other business from anyone? Right, and then we go into the next meeting.
The minutes would be reviewed when?
Next meeting.
Next week. So the issues that I had, I'll raise that.
Both, yes,
yeah.
Yes. Date for the next meeting, I think it's already set. Next week, Thursday. That's, what date is it? The 13th at 2 p.m. And we're going to try and do 3 hours if that's possible.
Chairman, just
yes,
to say that I may be absent from next week's meeting.
Oh, I didn't even know you were present at this one.
I have been present and listening attentively from the time I came on, Chairman.
I welcome you, colleague. It's very unlike you to be so silent during the course of these deliberations, but...
Well, listening is a good thing too, Chairman. It's not always about talking.
No, but for the record, seriously, I didn't mention your name, so I'm mentioning it for the record because I really didn't know you were online. Anyway, I'm happy you are. All right, so, you know, it really would be lovely to see everyone in the chamber next week, but we will play it by ear.
You will see me, Minister.
Very good. I appreciate that. And I hope the same applies to Senator Golding Campbell, but I know she had to leave. She had to leave earlier. Ladies and gentlemen, I want to thank you for this meeting. I think we made some good progress. Really appreciate the contribution by all and the willingness to bring some finality to these clauses. Mr. Edwards, we're going to be very specific next week, so we leave very little room for interpretation, if you will, and so we can try and see how far we can get next week. All right? Thank you very much, and meeting is adjourned.
No one is immune to mental illness. Your age, race, gender, social class, or economic status is no match for addictive behaviors, anxiety or eating disorders, depression, or schizophrenia. What is